Well, good morning, everyone. And like the previous speakers, yesterday's speakers, I'd like to thank the organizers, especially Nele and Alexander, for inviting me and to be able to come and participate in the fourth conference in this series. I must say I participated in 3 out of 4, so I'm doing not too badly. And it's been wonderful, I must say. Every time it's been a really interesting meeting, an opportunity to network and, of course, meet old friends. So the topic I've been invited to speak to is the subject of the international regulation of shipping from greenhouse gas emissions. And indeed, I would suggest that this is one of the most difficult topics in the regulation of shipping that we have ever had. And indeed, it's not a topic that we can address and dismiss quickly. Rather, it's a topic that we're going to have to live with for the next few decades. Why? Because this is all about the gradual decarbonization of shipping. And shipping essentially is very heavy energy reliant, and that energy is dominantly from hydrocarbons. So I thought I'll speak to you on this subject, and in particular, trace a relationship between, of course, the initiatives of the IMO as the maritime regulator, and, of course, the framework within which it is operating, the Paris Agreement, and specifically meeting the goal of the Paris Agreement. So by way of an outline, then I'll offer a few introductory words. I would like to point out the regulatory complexity. Why is it so complex to regulate shipping? And then more specifically, of course, emissions. And then introduce you to the IMO strategy for greenhouse gas emissions, or I should say initial strategy. And then offer words about the delivery of this strategy and offer concluding observations. So by way of introduction, going to the Paris Agreement, you will all recall here the overall target. Essentially aim at a temperature increase of no more than 2%, and ideally aim for 1.5 degrees centigrade. And you will recall, of course, that the Paris Agreement relies very heavily on a system of nationally determined contributions, right? Well, shipping is not expressly mentioned in the Paris Agreement, and indeed, it was intentionally so, although there were attempts to include shipping and aviation, but it was thought these industries are so different, they're so transnational, so global, they wouldn't really make an easy fit in terms of the responsibilities of states to report their nationally determined contributions. However, maybe they were not mentioned specifically, but they still had to contribute fairly to the achievement of the goal. Now, for us, of course, in the law of the sea, we know that we have a set of obligations here that do oblige states essentially to tackle atmospheric pollution from ships. First of all, you will recall Judge Pike yesterday reminded us of Article 192, this fundamental duty to protect and preserve the marine environment. And indeed, in the jurisprudence now, we know that there's essentially an important due diligence responsibility here, and indeed to take active measures. So in other words, sitting back is not good enough. States are expected to actively engage to resolve the problems of the marine environment. Now, I will remind you too that we do have a number of other relevant provisions here. Article 194, the duty to minimize pollution from ships, and of course, Article 212, more focused on atmospheric emissions, and indeed accompanied by Article 222 with essentially a duty to enforce. And these duties, of course, require a high degree of international cooperation. And we've seen indeed that cooperating to achieve the purpose of protection and preservation of the marine environment is indeed part of the general duty to protect and preserve the marine environment. And of course, what do we have to facilitate this? The IMO, with respect to international shipping. It is designated as the competent international organization with respect to international shipping. And I emphasize the definite article D. Now, there are, of course, a number of international organizations that also address shipping, but clearly when it comes to the regulation of navigational aspects of shipping as distinct from the commercial side, carriage of goods, for instance, clearly the IMO is the organization that is responsible, and therefore, under its own convention of 1948, it has been established as the machinery through which states cooperate to develop international rules and standards for, of course, domestication and enforcement, whether by flags, of course, also coastal, as well as port states. So for us, the IMO is, of course, the linchpin of the system of international maritime regulation. Now, going to ship emissions, how much of a problem are we actually talking about here? Well, shipping, if we look at some of the data that we have, which admittedly is dated, there were a number of studies that were produced by the International Maritime Organization, and two of these in particular stick out, and they are the ones that, in fact, we are using to push forward our efforts with regulating GHGs at this time. Well, the second GHG study of the IMO, published in 2007, essentially indicated that shipping generally emitted about 3.3 of global CO2, and international shipping specifically 2.7. Now you think, wow, you know, why are we getting up so much fuss here? It's such a small percentage. Yeah, but a small percentage is equivalent to Germany's emissions or the United Kingdom's emissions. So imagine if we were to leave Germany or the United Kingdom outside the Paris Agreement. Uproar, right? So shipping, of course, should not receive any more favorable treatment. Now, for us, of course, there is a range of GHGs that we ought to be concerned about, but clearly in shipping, CO2 is the major culprit. Now, if we were to continue on a business as usual scenario here, the study indicated that basically emissions by 2050 could increase anywhere between 150 to 250%, and essentially that is also in part as a result of expected growth of world trade. And what we have to remember here is that anywhere between 80 and 90% of global trade is carried by ships, depending on whose figures you use. The United Nations Conference on Trade and Development estimates it's more like 80%. Now, a study produced in 2014, updating essentially the earlier study, indicated that the projected increase with a business as usual scenario, in a sense, could be even worse, because 50 to 150% projected increase, even if we introduced enhanced energy efficiency measures. So, of course, this was very worrying. So, the IMO response here, and largely, of course, driven by the Paris Agreement, but not exclusively, because the IMO has been addressing emissions from ships for a very long time, long before the Paris Agreement, but nonetheless, the Paris Agreement was a real opportunity to push the organization into a direction that was absolutely necessary. So basically, I mentioned this is a complex area to regulate. So why is this the case? Well, we have to remember that ships are mobile on a global basis, and they are owned transnationally. So essentially, you can have a ship with a very international crew. It may be flagged in Malta, where I was born, but the beneficial owners may be in Greece, Cyprus, China, Germany. And then, of course, you can have a situation where, of course, corporations own corporations. So there is an endless corporate chain behind ship ownership. Now, this is not necessarily something which is intended to avoid national regulations, perhaps taxation, and so on, but it is actually a system that has developed historically to spread the risk, and also a system to enhance ship finance. So in a sense, it's not surprising that we have the system that we have. Now, you may own the ship, but you don't necessarily manage your own ship. Someone else may be navigating your ship. You might have a ship management company on the way. There might even be a charterer. So essentially, you can have a number of different actors that may or may not necessarily be in control of the actual navigation of the vessels. And then, of course, not all ships are the same. We have different kinds of ships that have different energy uses. And then apart from that, we have to bear in mind some of the issues that were brought up yesterday with respect to ports. At the end of the day, ships have value because they can trade, and they trade because they enter into ports, load cargo, unload cargo. And today, of course, the world economy depends very heavily on just-in-time delivery. So ships are like floating warehouses very often. And therefore, speed, timely arrival is of the essence. So that is an issue for us when we start discussing things like, oh, why don't we get ships to reduce their speed? Yeah, well, it's not that simple. You still have to arrive in time in another port and not lose your berth, because if you lose your berth, you might have a few extra hours, maybe a few extra days before you discharge, and then, of course, that means that you incur penalties for not having discharged your cargo within the time limit allotted to you. There are issues of risk management and indeed amortization of investment in shipping, 20, 25 years perhaps. So if we introduce a regulation today, we have to bear in mind that we have tonnage, which is subject, in a sense, to particular finance agreements. So we have to think in terms of how do you phase it out, basically. So you cannot simply say, look, we're going to introduce a regulation today, and by tomorrow, everybody's going to change. No. In essence, it's like essentially having a moving object at great critical mass, and somehow it needs to be slowed down while you start another one and try to build speed with it. And of course, all this has implications for world trade because of the heavy reliance on shipping. And the reality is, too, that the capabilities to administer shipping are not equal around the world. We have great diversity, and that's one of the major issues we have, essentially to ensure that international maritime rules and standards are applied effectively. Now, bear in mind that these issues all bear on the question of how to regulate GHGs, but at the same time, shipping is already the most heavily regulated ocean use. You know, depending on how you count your international instruments, but the IMO estimates that there are more than 40 conventions and protocols that regulate shipping in one form or another. And then the number of codes and guidelines is endless. So essentially, you have a very complex system of regulation. But the complexity doesn't end only with the maritime regulation. The reality here is that we are dealing with an issue which really brings into perspective how much of international law has been developed into silos. And effectively, we think in terms of mitigation in shipping. So in other words, our ability to reduce emissions from shipping, well, sure, we are guided here by a goal from climate law, international environmental law, Paris Agreement in particular, but of course, UNFCCC, Kyoto, and essentially, if we look at the climate regime, if I can perhaps simplify and call all these together the climate regime, as a starting point. But of course, we're dealing with ships that navigate, that use ocean space. We're dealing also with the international law of the sea. There are issues of jurisdiction of their ships, how the jurisdiction may be exercised, and so on. And of course, clearly, the maritime law dimension is how we actually substantively regulate ships. But there is also potential an international trade law dimension here, which was mentioned briefly yesterday. So essentially, we see here potentially a convergence of regimes which can have implications for how we regulate GHGs from ships, because in the end, in the event of disputes down the road, and of course, we lawyers will have to think in terms of disputes and dispute settlement procedures and mechanisms. Well, the issue with, for instance, international trade law here is that international trade law has its own dispute settlement system, separately from essential dispute settlement system that we have, for instance, within the law of the sea. And the principles and rules applicable are very different from those that would be applied in the international law of the sea. On top of that, of course, let's not forget there is a potential regional dimension, especially here within the European Union. And indeed, I think it was Henrik yesterday that mentioned the MRV, the system essentially for ships to report data on fuel usage, distances, and so on. Very important data that is going to be critical, essentially, to better understand how we ought to regulate emissions. Now, there have been efforts over the years, and I mentioned that the IMO is not new to emissions regulations. Indeed, the IMO's efforts here go back really to 1991. So 1991, that's before the UNFCCC was adopted, right? And effectively, that was an early effort at addressing air pollution. That effort developed gradually, leading to the adoption of MARPOL through essentially the Protocol of 1997, introducing Annex 6, very important instrument for my presentation. Kyoto Protocol 1997, you will recall a provision specifically speaking to Annex 1 states, essentially, and states here agreed to pursue discussions through the IMO to reduce GHG emissions from marine bunker fuels. So that was always on the IMO agenda since 1997. There's been a lot of cooperation between the IMO and, of course, the UNFCCC Secretariat and, of course, the SBSTA process, the scientific process. And that has been going on now for years and years. And the MEPC has been deliberating on GHG emissions really since 1998 with MEPC 42. In 2012-2013, we had very important deliberations at the MEPC that led to the adoption of Chapter 4, a new Chapter 4, the regulations on the energy efficiency of ships, introducing the Energy Efficiency Design Index, the EEDI, was mentioned yesterday, as well as a mechanism, a plan called SAMP, the Ship Energy Efficiency Management Plan. Essentially, the EEDI was introduced as a mandatory requirement for new ships, but the plan, the energy management plan was essentially introduced to apply to all ships to essentially enable them to better use energy and reduce emissions. But the really major development here was the adoption of this strategy as a result of a roadmap adopted in 2017, leading to the adoption of the strategy in 2018. So if we look at the regulatory roadmap, in essence, this is where we are. And you see there a timeline, in essence, from the adoption of the strategy in 2018, and basically leading all the way to 2023 with a series of steps to enable the readoption, but of a revised strategy. So what we had adopted in 2018 was an initial strategy, in essence, to try to frame present actions, but also future actions for the short, medium, and long term. And then after this first 5-year period, and on the basis of better data, we'll be able to project the long-term decarbonization plan. And indeed, this is the strategy. This is literally the table of contents. And for our purpose, of course, what is important to focus on is the candidate short, medium, and long-term measures. In other words, exactly what sort of measures are actually going to help us, hopefully, to reduce GHG emissions from shipping. But also important for our purposes is barriers and supportive measures. Because here, this discourse has important implications for equity among states. This is not simply the sterile regulation of shipping. No, we're talking here about potentially affecting routes and potentially the movement of trade and potentially, of course, distribution of wealth. So this is no simple topic. So let me take you through some of these critical issues. Important for our purposes is to think in terms of what are the ambitions of this strategy as a whole. And indeed, the intention here is to reduce the carbon intensity of ships gradually by using the EEDI, the Energy Efficiency Design Index. So essentially scaling up through phases in terms of gradually increasing the efficiency of ships. That's essentially what that acronym stands for. But eventually thinking in terms of reducing the carbon intensity with respect to transport work, so carriage of goods, passengers, across the industry by at least 40% by 2030, but continuing efforts so that by 2050 at least we'll have reduced this by 70% using 2008 as a baseline. And then, of course, if you're wondering what happens after 2050, well, the aim here is to continue to eventually decarbonize, wean the industry of hydrocarbons. So the idea is for emissions to peak basically as soon as possible by 50% while continuing to enhance efforts. So we have a number of principles here that guide us in this process, and Henrik mentioned no more favorable treatment tied closely to non-discrimination. We should treat ships, in a sense, in a comparable manner because they're owned by businesses, essentially, and they're in competition with each other. So they need a level playing field. So we cannot really start favoring one flag over another. But we're also concerned about common but differentiated responsibilities. Essentially, a principle of international environmental law that somehow had to be reconciled with no more favorable treatment in the IMO. This wasn't an easy process, and indeed, for a long time in the Marine Environment Protection Committee, discussions stalled precisely over how to reconcile these two principles. But now, of course, with the Paris Agreement, it's clear that it's not just CBDR, but it's CBDR in accordance with respective capabilities of states and in the light of different national circumstances. So for us, in particular, least developed countries, as well as small island developing states are in the forefront because they are the ones that are most potentially impacted. At the same time, regulation is supposed to be evidence-based while utilizing precaution. So how we do that is not that simple, but certainly at least this is a principle that is supposed to guide regulations in the IMO. So now we are already into the short-term stage, starting last year until 2023. We are looking at adopting three kinds of short-term measures here, potentially, at least those are the ones that we are considering. There are those that are clearly within the IMO instruments, and there are those, of course, that are within the IMO instruments, but perhaps need some additional work, additional data to determine what their impact might be if we do proceed with these. And then there are others, basically, that do not really require any particular data. So essentially, we have three groups of measures that are currently being considered, and a number of states have already put forward proposals for MEPC 74 to meet shortly. So what are the possible short-term measures? Essentially, these are defined as actually helping to reduce emissions. They may be a mixture of mandatory and voluntary. If you look at the ABC that I showed you earlier, we could be looking here at accelerating the EEDI process, so force upon ship, this goal-based approach, essentially to increase efficiency, maybe with higher levels of percentages, extend the application of this index perhaps to a broader range of ships. Indeed, the so-called SEMP, the management plan, energy management plan for ships, at the moment it's voluntary. Make it mandatory and expand it to a broader range of ships. Enhance the volatile organic compound controls as well. So those are clearly all within Annex 6 of MARPOL. But then there's a second group, B, route optimization, potentially explore speed optimization and potentially speed reduction. We have to see exactly what that might mean. And also promoting alternative fuels. And then ultimately see, of course, encourage the adoption of national action plans. Port measures, in relation to yesterday's discussion, these could potentially be key players for our purposes, and so on. So, of course, there are a number of issues here, because there is the issue of impacts produced by all these measures, and who is supposed to determine what these impacts are. Clearly, proponent states are expected to indicate what they anticipate to be impacts, but of course, there will be IMO collective determination. The reality is affected states will also have to watch out for their interests. And of course, we do have the epistemic communities out there. In essence, the experts like people in the room here, and a number of organizations, NGOs, that are very carefully watching this discourse. But the reality is that it's not that simple. Let's take, for example, speed. So in theory, speed has been estimated at being able to reduce emissions by 1/3 for containers, bulkers, and tankers. These are some of the biggest ships that you really want to reduce their emissions. But in practice, there are problems. Slow speed is not necessarily the optimum speed for which a vessel has been built. There might be issues of safety and maintenance if you reduce the speed of ships. And also, if you reduce the speed and therefore you essentially mess up with just in time, you could be pushing shipping onto other forms of transport, maybe more road, more rail. Do we want that at a time, especially in the EU, where we're trying to promote short sea shipping. We want to move more cargo by ships rather than by road or rail, right? And if you have slower speeds, you potentially have longer voyages. What if you're carrying perishable products, agricultural products from Chile, Peru, that are supposed to make it to China? If you essentially reduce their opportunity to market these products, they might be out of a market. And then, of course, there's an issue here. If you reduce you reduce the speed of ships, there are already ships that are very efficient out there. Why do you penalize them? And then, if you have slower speeds, you could have potentially a problem with exotic species and biofouling. The buildup on the hull could be a problem. So it's easier proposed than implemented. So we do not really have full agreement on how to use this as a potential measure. But the port-ship interface that was mentioned yesterday, there's a lot of potential here because ships, after all, provide services in ports, but they're receiving services. So ports could provide, for instance, what is called cold ironing, so essentially power supply from the shore, as long as, of course, the power provided by the ports is in itself provided from renewables. There are opportunities to optimize port visits and a range of measures can be taken in ports. But the problem here, this is where perhaps the differences in capabilities between states starts shouting at us. Because not all ports out there may be in a position to necessarily provide the range of different fuels that we're going to be seeing on the market. So essentially, that could put some ship owners in a difficult situation and also might make some ports essentially uncompetitive if they are not able to provide the range of the diverse fuels that we're going to be seeing on the market. So those were the short-term measures, very briefly here. But there's already been discussion here for the medium term, 2023 to 2020. Essentially, we're going to see an expansion of these short-term measures here. But perhaps the most significant measure here for the medium term will be the potential introduction of a market-based measure. And this is going to be very interesting in shipping because essentially the IMO was not designed to do market intervention. The IMO was designed really to regulate ships, international rules and standards. But market-based measures such as, for instance, a levy on shipping, or for that matter, a cap-and-trade system. Well, these essentially are novel things. One will have to think in terms of how the governance system of the IMO can accommodate these, or whether we should rely perhaps on some other institution mechanism outside the IMO. And as you see, the more we go into the future, the long term, the fewer the bullets, because essentially, how far into the future can we look? And indeed, this is one of the major challenges we're dealing with. How do you manage uncertainty? The more we look into the future, the more uncertain things are, because we are going to be placing our faith in technological development, and that is why we're pushing goal-based standards. But the reality is that it's difficult to foresee perfectly when certain technologies that we know we will have in the future, when they might actually be available. There is a range of impacts here that will still have to be ascertained, and you will see here geographical, the cargo value and type potentially, countries that have transport dependency more than others, such as small island states, everything is connected to them by the sea, potential costs of transport, socio-economic impacts, food security issues for some countries, yes, this is also a potential impact, and so on. So there's a range of impacts that we still have to grapple we have to figure out essentially how do we even develop a methodology to determine these impacts. There will be, of course, a range of supportive measures, clearly on the technical assistance front in particular. But there are increasingly small island development states out there that are saying, look, supportive measures are not enough. We need systems of compensation. You have to figure out, basically, a system that will kind of insure us against potential risks and then compensate us. And of course, that is going to be very, very controversial. But if we look at the big picture, strategy delivery, so we're going to be relying very heavily on MARPOL, Annex 6, lists of measures, technical, operational, and so on. There will be market-based measures at some point in the future. We have to see when and what sort. And we have a range of structures that are going to be delivering on this system. IMO is the regulator, but let's not forget the industry organizations, International Association of Classification Societies, as well as the International Standards Organizations, among others. They play a critical role in maritime regulation that is not, to my mind, acknowledged sufficiently, but they are essentially central to maritime regulation. And ultimately, of course, how do you keep an eye on the system and make sure it's going to work? It's going to be very complex. Remember the silos metaphor that I mentioned earlier. So in essence, we're going to be looking here at a number of regimes that have to work together in gear. They're going to be, in essence, supporting each other. So clearly, the Paris Agreement is there, but maritime regulation plays a key role to feed into the Paris Agreement goal. Of course, we have the various jurisdictions in the law of the sea, those states that are responsible for their ships or that may have regulatory powers over ships moving to their waters or calling into their ports. There is a role even for private law, but critically, of course, let's not forget the role of capacity building, technical cooperation, and technology transfer. And then, of course, we still have to figure out where does the WTO fit in here, especially if there are disputes. And let me conclude here. I realize I'm now over my time. A few observations here. Essentially, the IMO has proceeded on the basis of knowledge that we've had really, which is now quite dated. And almost every month, there's something new that we're learning about climate change. And very recently, for instance, you will have heard that clearly the IPCC's report on 1.5 suggests that we need to be a lot more ambitious to meet the Paris goal. But look, a couple of other studies indicate that we still don't fully understand ocean thermal storage, and that indeed the oceans themselves might be reaching their absorptive capacity to absorb, in a sense, heat and carbon. But a couple of weeks ago, we learned too that in the Arctic, things are a lot worse than we thought. That essentially 3.5 to 5% degree increase by mid-century is now locked in. So we're already well beyond the Paris goal in the Arctic alone. And we know the Arctic is the most directly affected, if you want, parts. Essentially, the Arctic is impacted twice the rate of the rest of the planet when it comes to impacts on climate change. So essentially, a range of other observations there. I will not go through all of these, but perhaps I would conclude with the last one. I really think that the introduction of market-based measures will raise some interesting questions concerning the governance of the IMO and whether perhaps we might see the need for some structural change in the IMO to be able to support a market-based measure. And I apologize for taking a little bit longer than I should have, and I thank you all for your kind attention.